Yes, I think it was a very successful process. It was a very thorough process. We're talking about the oral evidence because the inquiries have been going on before that, but obviously the oral evidence brought it very much to the homes of everyone. And I think, as I said in my speech today, the way it was managed, the thoroughness of the inquiry, the publicity, the reporting, both on GBC and in the Gibraltar Chronicle, I think it shows that we've got a robust, transparent system, freedom of the press, um, democratic principles and transparency which have come across during the entire inquiry process.
You mentioned the OPC's drafting of 31 bills. There must be some complication, some difficulty in drafting legislation in a post-Brexit world, but also with a view to being compatible with a treaty negotiation with Spain.
It's a very good point to raise. I mean, on the one hand, there is a lot of domestic policy that is being implemented, and that is just going at pace, and that is happening. There's a lot of space for domestic policy legislation to be done. Bear in mind that whilst we were members of the EU, that membership directly or indirectly accounted for, I think it was about 70% of total legislative production in Gibraltar. So just imagine what's been removed. So that is a space which domestic policy has occupied, and that is great because we'll be seeing the results of that very visibly. So that's been happening on the one hand. On the other hand, and your question is spot on, there are many areas of legislation which the government would want to amend and would like to amend, but it's not doing so because the treaty and the outcome of the negotiations will have a direct impact on that. For example, legislation on civil status, legislation on residence cards in Gibraltar. All that is of direct relevance to the treaty that we are discussing, and therefore the legislation will have to react to it. The treaty will also give rise to a need for a lot of domestic implementing legislation.